Hi, my name is John Wyvill. I'm the Executive Director of the Nebraska Commission for the Deaf and Hard of Hearing. Today, we are having our continuing series of our advocacy handbook on the legal system. And my purpose of my talk today is to provide you with a simple overview of the legal system here in Nebraska and some common issues that we address in our state. The majority of the information I will be covering will be found on pages 27 through 33 in the Advocacy Handbook. My presentation will provide you with a general background of the common legal issues that we address, and of course, we cannot give you any legal advice. So with that disclaimer, please understand that any specific legal issue that you may have, we would strongly urge you and recommend you to see a private attorney for advice. And please also note that this is an informational only presentation and not should be relied on legal advice. This is just to give you an understanding of the various laws that you can use to help you advocate for yourself in the community. Now, the legal system is designed and to cover 4 different areas. First is what is called the Rehabilitation Act, Section 504. We refer to that as Section 504 law, and basically says that if you receive federal funds, you are prohibited from discriminating in programs or activities that receive financial assistance from the federal government. The second portion that we have is called CRIPA, C-R-I-P-A, which is the Civil Rights of Institutionalized People Act, which provides the United States Department of Justice the right to protect individuals that are in the care of state and local institutions. The next law is the Americans with Disabilities Act, or ADA, which mandates that individuals with disabilities are not excluded from or denied benefits of services, programs, or activities of a governmental entity or a public entity. State and local law enforcement and state agencies are covered under this. Those are the 3 federal laws that we deal with. The fourth area that we address is the Nebraska Revised Statute, Section 20-150, which secures the rights of the deaf and hard of hearing who cannot readily understand or communicate in spoken language, and who cannot equally participate or benefit from proceedings from state agencies or law enforcement unless an interpreter is provided to ensure effective communication access. With that backdrop, those are the common 4 legal areas that we address in terms of advocacy for those who are deaf, hard of hearing, or deaf-blind. Typically, the communication access and legal issues that we interact with involve a routine traffic stop, interacting with the court system, or interacting or being in jail either short-term or long-term. These are the areas that most deaf or hard of hearing individuals encounter the legal system. There are a couple laws that apply and impact us. These are both Section 504 and ADA makes it very clear that the law enforcement agencies are obligated to take action to ensure effective communication with individuals who are deaf and hard of hearing. CRIPA law allowed for the U.S. Department of Justice to come in to protect the rights of individuals that are in the care of state or local institutions. And law enforcement and jail officials must ensure that programs are accessible and activities are accessible. Nebraska state law also outlines some very specific requirements to communication within the legal system. Now, there are a number of legal concerns that we address in the legal system involvement for people who are deaf, hard of hearing, or deaf-blind. that involve lack of or denial of services. One of the most common ones is method for effective communication with law enforcement officers, lawyers in the courtroom. There's a duty and an obligation to ensure that communication access is being provided. Second is an access issue to effective communication. We're working with private attorneys. And then there's another third is the use of effective communication while incarcerated, including access and sufficient time to use the telephone. And then finally is one that is often misunderstood by law enforcement and other individuals, is that if a person who does not rely on spoken language, it's kind of difficult to have effective communication when your hands are in handcuffs. So those are some of the areas of legal concern. I will focus my attention now on the ADA, the Americans with Disabilities Act. Law enforcement agencies must consult with the individual about the choice of auxiliary aids or services that would result in effective communication. Law enforcement individuals, state agencies, attorneys, and the police all have to provide equal access to the services by providing accommodations necessary to ensure effective communication. And that is especially important with the deaf and hard of hearing. Now, there are some ways and sometimes that the law enforcement or state agencies may not be able to provide access. And they may provide not access in a couple situations in which they would not provide accommodations that would fundamentally alter the law enforcement service or result of an undue financial or administrative burden. So when they're having that conversation that would fall for a fundamental alteration or undue burden, the police or law enforcement must take other action to ensure that communication with individuals is effective as possible. So they may deny the requested accommodation, but they still have a duty to provide you with effective communication access. The next federal law that comes into play is the Rehab Act, Section 504. It basically says if you receive federal funds, you got to play by the federal rules. And that means you must provide accommodation. The right of the deaf or hard of hearing person is paramount in that area. Many police departments in the United States receive public assistance from the federal government and therefore are subject to the 504 requirements. All individuals who are deaf and hard of hearing must be informed of law enforcement agencies' obligation to have a qualified interpreter, cart, assistive listening devices, or other auxiliary aids or service at no cost and during all communication with law enforcement. The next item is CRIPA, the Civil Rights of Institutionalized Persons Act. And those entities that are impacted or covered by that include state and local jails and prisons, juvenile correctional facilities, public nursing homes, mental health facilities, and institutions that house individuals with intellectual disabilities. This law was enacted to ensure that people who feel uncomfortable reporting issues of abuse in government-run institutions. It just allows the Attorney General's office on the federal level to come in and enforce those rights. The next issue and area is, after covering these three federal laws, is that there are some very specific Nebraska state laws that apply in our case. And that can be found in Nebraska Code, Section 20-152. And it states that whenever a deaf or hard of hearing person is arrested or taken into custody for an alleged violation of state law or ordinance, law enforcement shall provide a licensed interpreter for any interrogation, warning, notification of rights, or taking of a statement unless there is a waived statement by the person. No arrested deaf or hard of hearing person otherwise eligible for release shall be held in custody waiting for a licensed interpreter to show up. a licensed interpreter is being required to be provided as soon as possible. Now, it's also another thing is that no written or oral statement or admission made by the deaf or hard of hearing person in response to any law enforcement officer's question can be used against the deaf or hard of hearing individual in a criminal proceeding. For example, a statement that was made or elicited through a licensed interpreter can only be admissible if it's made knowingly, voluntarily, or intelligently, or the deaf or hard of hearing person waived his right to an interpreter, or that waiver in the statement was made knowingly, voluntarily, and intelligently. So, to recap, is the right of a deaf or hard of hearing person to an interpreter can only be waived in writing. And if you make a statement, you also have to make sure that it is waived. Now, if the law enforcement or others do not provide an interpreter, that is not a defense to a prosecution of a criminal case. For example, if you've been pulled over for speeding going 65 in a 45-mile-an-hour zone, if they do not provide you with an interpreter, that does not mean that they can provide you, that they have to let you go for the speeding ticket. That just means that if an interpreter is not provided, is that any statement that you made may not be admissible in court. So many people forget about that. Just because they don't provide you with an interpreter doesn't mean that you may be exonerated from the charges. In addition, there are some other specific statutes that you need to be aware of in this statute. Is that if you receive a subpoena or a written request to attend a court hearing, they are required to provide you with a licensed interpreter. That is the state law. And if a licensed interpreter shows up and is not being provided effective communication, you have a right to request an additional interpreter or a different interpreter. That interpreter must be provided to the individual if it is not effective. So make sure to understand if the interpreter is not effective, you need to stand up for your right and explain why the interpreter is not being effective. And then the courts and the legal system or the law enforcement have a duty to provide another interpreter. And then the last item is that while it is not commonly known, is that an interpreter, if interpreting in a situation in which privilege is applied, very similar to doctor-patient privilege or attorney-client privilege, then the privilege also extends to the interpreter. So please keep that in mind. So in conclusion, I've just given you a few items, an overview of our legal system in the ways that certain laws may apply. As I mentioned, there are 4 laws that may apply to you in routine traffic stops, in court, and in jail. Those include the Section 504 of the Rehab Act, CRIPA, ADA, and then Nebraska state statute. But please keep in mind that this is just a general overview of the law. So if there is any specific legal issues that come up, I would strongly encourage you to contact a private attorney, Disability Rights Nebraska, or speak with someone that has authority in these areas in order to represent you in court or in other proceedings to make sure, because every single case is different. You cannot rely on this specific thing as legal advice in your case, but just give you an overview to know what your rights are. Also, I would take this opportunity to thank you for your time, and also make sure that you continue to watch our other webinars for other chapters of our advocacy handbook, and to provide you with the tools necessary for you to effectively advocate. I appreciate the opportunity to be of service and help to you, and I hope this and this series has been of some value and help. Have a great day, and look forward to seeing you soon.